So one thing that happened over this weekend is Purdue is back in the news on the Sackler family. If you're not too familiar with them, they've had a lawsuit that's been in place for at least the past decade, going on two. And what makes this particular decision so important is it's a final decision that'll be coming down. That means in as early as spring 2026, Purdue won't exist anymore. So let's dive right into what PBS had to say about it. So here we've got a judge that says he'll approve an opioid settlement with Purdue Pharma and the Sackler family. A federal bankruptcy court judge on Friday said that he would approve OxyContin maker Purdue Pharma's latest deal to settle thousands of lawsuits over the toll of opioids that includes some money for thousands of victims of the epidemic. The deal, overseen by U.S. bankruptcy judge Sean Lane, would require members of the Sackler family who own the company to contribute up to $7 billion and give up ownership. The new agreement replaces one the U.S. Supreme Court rejected last year, finding it would have improperly protected members of the family against future lawsuits. So this is part of the big decision that came down this weekend. And what makes this unique from the Supreme Court case is, like it mentioned here, that the Sackler family was seeking protection that would shield them from future lawsuits. Purdue became a household name in the U.S. as the maker and promoter of OxyContin, a prescription painkiller it promoted as safe despite being aware of it being both highly addictive and widely abused. The company declared bankruptcy in 2019 after it was hit by thousands of lawsuits brought by states, cities, and families. It later pleaded guilty to criminal charges, including defrauding health agencies and making illegal payments to doctors. The kind of shield granted to the Sacklers in this deal has been a critical feature of other high-profile settlements, including those involving the Boy Scouts of America and the Catholic Church. So this litigation all actually began back in 2007 with Kentucky filing lawsuit. And in 2015, Kentucky received $24 million as a settlement. And they were the first state to kind of get it on the record. And since then, prior to this declaring bankruptcy in 2019, prior to that, more and more states were joining the coalition. In 2019, it was 36 states that were filing against it, and those totals were equaling trillions of dollars. And as of today, all 50 states, as well as 4 U.S. territories, are also part of this lawsuit. And if we talk a little bit more about the backstory, OxyContin was often used as an entryway into harder drugs, such as heroin, and has been blamed for driving the opioid crisis. Since 1999, a few years after the drug became available, deaths from the opioid overdoses have surged eightfold to more than 80,000 annually. Court filings allege that the Sackler family was long aware of the legal risks and actually withdrew $11 billion from the company in the decade before its bankruptcy. They stashed much of the money overseas while using some of it to pay company taxes, making recovery difficult. So this is important because they've been in litigation since 2007, but this article from the BBC only covers up to like the 2019-2024 decisions. So over the time that they've been in court with all this, they've been quietly tucking money away, making it harder and harder to access so they can hold on to more of it. And there is another article that I read where they even planned to keep several $100 million after this particular settlement. So that way, if there's future litigations, that all plays into it too. So even though this is one of the biggest, if not the biggest settlement of any pharmaceutical company in U.S. history, it is controversial because there's a lot of people not going to get paid. A handful of objectors spoke Thursday at the hearing, sometimes interrupting the judge. Some said only the victims, not the states and other government entities, should receive funds in the settlement. Others wanted the judge to find members of the Sackler family criminally liable, which is something that Lane said it's beyond the scope of the bankruptcy court, but that the settlement doesn't bar prosecutors from pursuing. Not only does this particular ruling grant an additional $1 billion compared to the 2024 settlement that was offered before the Supreme Court, but this strips the Sackler family of being shielded for future litigation. Members of the Sackler family would be required to pay up to $7 billion more instead of $6 billion, and they have to give up ownership of Purdue Pharma. The company would get a name change to Noah Pharma, and the new overseers who would dedicate future profits to battling the opioid crisis. That could happen as early as spring 2026. There's also some non-financial provisions where certain members of the Sackler family will be required to give up their involvement in companies that sell opioids in other countries. Family members would also be barred from having their names added to institutions in exchange for charitable contributions. And in situations where that's already happened, their name has already been removed from museums and universities. And what I think is the most important thing is that company documents, including many that would normally be subject to lawyer-client privilege, are going to be made public. So part of what makes this controversial is that not only are there the victims that are seeking justice, but there's also several local and state governments that are trying to use this money to fight the opioid crisis. And what also makes it tough is that many of the people who are victims were unable to prove that the problems they have are directly related to OxyContin. So therefore, like, many people aren't even going to get a penny of this. So unlike other major opioid settlements, individuals harmed by Purdue's products would be in line for some money as part of the settlement. About $850 million would be set aside for them, with more than $100 million of that amount carved out to help children born with dealing with the opioid withdrawal. All of the money of the individual victims would be delivered next year, and it would take up to 15 years for governments to receive their full allocations. About 139,000 people have active claims for the money. Many of them, however, have not shown proof that they were prescribed to produce opioids and will receive nothing. Assuming about half of the individual claimants would qualify, lawyers expect that those who had prescriptions for the last 6 months would receive about $16,000 each, and those who had them more briefly would get around $8,000 before legal fees that would reduce what people would actually receive. So people will have until March 1st to agree not to sue the Sacklers and apply for funds. And this is where, for me personally, I think this is kind of a catch-22. It's like, do you try to, apply for these funds and get into what you want from the settlements? But in doing so, you forfeit the chance to go after them for either more as well as any kind of criminal charges. So it is sort of a bittersweet situation. I definitely want to try to cover it more as things develop and see where things go. It is it's a record-breaking lawsuit settlement. It's billions of dollars, and it keeps the Sacklers vulnerable. But the question is going to be who's actually going to go after them, because in order to take this settlement, you have to forfeit that right to do so. So we'll see where things go. But
I haven't heard of Purdue Pharma in the news for years, but I'm glad it seems like people are actually getting some justice for all the pain and misery they've caused. And it's nice to see things are moving along. It kind of sucks about the whole not able to go after them again in the future if you take this deal kind of a thing. Is that the shield thing that you were talking about? Is that what that is, or is that it's separate?
It seems related, similar to what was going on with the Boy Scouts of America and the Catholic Church. So the shield that they wanted said that they would get nothing. You can't go after them at all. But now that was part of the Supreme Court decision of last year, which was a 5-4 vote, so it was close. But the decision by the Supreme Court was that no, you can't be protected against future lawsuits. So if people want to go after you, they can. But I think with this particular settlement, there is like a small shield in place of, if you take the buyout now, then you can't sue. But that doesn't mean that people won't sue going forward if they reject this, which is something the Sacklers sought because they don't want any trouble.